everybody. How is everybody this morning? BNN Howard, sorry you are not feeling well. Hope you are feeling better soon. Good morning, Brenda. Brenda says, thank you for always being reliable. Very grateful. You're very welcome. Thank you for being here. Hello, Paulette. Which cards are you speaking about, Paulette? Good morning, Nancy. Good morning, Muffin Top. Good morning, Comptoot. Christy, good morning. Sammy, good morning. Shannon, good morning. Mariah, good morning. Good morning, everybody. Thank you for my fix. I like that. Good morning, Nana. Good morning, Amy. Good morning, Barbara. Good morning, Bonnie from Canton, Ohio. Good morning, everybody. Thank you for being here. Please hit that like button on your way in. 19 likes, 43 people in here. It's free, you guys. It lets everybody know that we are live. Now, this morning we have Chad Daybell on the docket again. And today, I believe it's the motion to sever.
Hello?
Good morning, Lorna. And that's my sister. She will be in shortly when she gets home. She is driving, but she will be in here. And she's been super sick all week, so. Lorna, good morning. There she is. She's here, but driving. She's got my little niece, Gabby, who's also sick. There she is. There's Gabby. Thank you guys, for being here. Both of them are sick this morning, and here they are. Thank you. I love you, sis. I love you, Gabby. Good morning, Dawn. So, yes, I believe it is going to be the motion to sever this morning. Hopefully it. Thank you, sis, for doing that. Hopefully they get this all wrapped up this morning, and then they will be back. Let me just get my... Hello, Teresa. Good morning. We will be starting at 11:30. And then Chad is back in court again on the 23rd. And that's when you guys aren't going to want to miss that one either. That's when they're going to be fighting about the motion to dismiss all charges. And I do not believe that the defense is going to be granted that. And then they have a second and third motion to dismiss, and they want Woods and Smith off the case. So that is all going to be happening on the 23rd, starting at 11:30 a.m. Eastern. So you don't want to miss that. That is this coming Wednesday. So we'll be covering that too. What else do we have? I think we may have Letitia on the 25th. And then we have Barry again on the 30th. So we have a few more coming up. Warrior of Justice. Hello, good morning. So let me just get this set up, you guys. Oh, what else was it? There was something else I had for you guys too that I had come across. Oh, the Barry Morphew thing. I have got wind of. I have not been able to verify it yet, but I have got wind that the judge is also going to We know that he's not allowing any testimony in the trial regarding the domestic violence. I've also got wind now that apparently, now this is not verified yet, that they are trying to have the Barry's truck data and his cell phone data taken out also. So I don't know if the judge has ruled on that yet, but this is what I've been hearing, is that they've got the defense has got the domestic violence stuff taken out. Well, now they're going after the truck data and his cell phone data. No, Muffin Top. When I talk about the case being severed, John Pryor wants Chad Daybell's case severed from Lori's. Right now, the case is their cases are gonna be held together. So Lori and Chad are both going to have their trial at the same time, same courtroom, everything. So John Pryor is trying to have that severed. They were severed at the very beginning. The prosecution had them joined, which they call a joinder. And now Pryor is going for a severing of the cases, which means separating them. Yeah, there's a lot of shady stuff going on in the Morphew case. So I don't know. Like I said, you guys, that's not something that I can verify yet, but I have got wind of it from a little bird. I'm going to leave it like that, that they're trying to get his truck data and his cell phone data thrown out also from the trial. Yes, please smash that like button, you guys. 38 people in here, 71 viewers. It helps get it out there that we are live. And it also helps so that way I don't got to keep repeating myself. You can pop out of chat, live chat. Go click that like button. When you come back in, please make sure you have live chat selected at the top. That way you don't miss any of the chat. And it is free. And also lets me know that you guys like me covering this stuff. Barry is on the 30th. Yes, please smash that like button. It is free, you guys. It gets us up there in the algorithm, lets people know that we are live. A lot of people don't get the notifications. The more that it's liked, the algorithm picks it up and shares it out. So please do that. 48 likes, 68 people. It is unbelievable what Barry Morphew lawyers are trying to pull. And there's so much in there. Thank you, Teresa. Thank you to everybody who has smashed that like button. Like I said, it gets it out there. Let me just check here. We've got some members in here. Dawn. From the members. Thank you for being here. CompToot, a member also. Thank you guys for being here. Bearing D2, also a member. Hello, Bebop. Amy Celeste, hello, hello. Shannon's Copper, hello. Fancy Nancy, hello. Fluffy Hedgehog, hello, hello. Good morning. Can't speak yet this morning. So yes, thank you for all the members for being here also. If you do want to become a member, the join button is on the main screen of my YouTube channel. I wonder that too, but that has all been sealed. So we won't know about that until the next hearing, which is on the 23rd, when they fight that. So hopefully they don't close that off to the public, that we can watch it in the courtroom like we are going to this morning. It starts in about 5 minutes. Cindy Lynn Walker, hello, hello. Nancy Santos, hello. Yeah, I've got one. I've got one that I just made a coffee just before coming on. That's okay. I got 2 tongues this morning, muffin top. It's like I went first thing in the morning when I get up. I go over and make sure everything's cool at Mama's, and I just couldn't talk worth crap this morning. So we will be starting at any time, you guys. As soon as this starts in the courtroom, I will be bringing it to you. Okay, let me just see here. I'm just checking out something else here, you guys, before I say it. I want to try and verify it here first. Okay, so there's an update. Everybody's going nuts on Twitter about this. But on March 17th, around 2:22 p.m., a female inmate at the El Paso County Jail died while in custody. The inmate found was unresponsive in her assigned cell. She passed despite life-saving measures by on-scene personnel. And I don't, everybody's thinking that it's Lori. That's not going to be Lori. El Paso. Oh, sorry. That's, oh, they're thinking it's Letitia. Okay, thank you, sis. Thank you, thank you. Okay, so they're thinking that this could be Letitia. She passed despite life-saving measures by on-scene personnel. The identity of the deceased female will not be released until the coroner's office makes positive identification and the next of kin is notified. So they're going crazy online about this. This was released yesterday. Let me just... Muffin top, my fellow Canadian. So yeah, they're thinking because there's a female that died yesterday at the El Paso County Jail, and that's where Letitia is being held, and everybody's going nuts thinking that it may be her. So let me just... Okay, where did I just see that now? Damn it. Yeah, so we don't have... Hang on a second. Okay, let me just make sure they're not starting yet, you guys. Okay. And they will be starting any minute, but I want to show you guys this. So here it is here. I'll just share this quickly. We can go over it once the live is done, if I remember. Here it is here. El Paso County Sheriff's Office, March 17th at 7:40 p.m. On March 17th, around 2:22 p.m., a female inmate at the El Paso jail died while in custody. The inmate was found unresponsive in her assigned cell. She passed despite life-saving measures on the scene. Personnel responders from American Medical Response and responders from the Colorado Springs Fire Department. The identity of the deceased female will not be released until the coroner office makes a positive identification. So that's what we have. And people are going nuts thinking that it could be Letitia. So I will keep an eye on that. 2 years yesterday that they found Gannon's body. So I am going to be keeping an eye on this. That's odd, Cheyenne. Thank you for sharing that. It's odd that this female died yesterday. And yesterday it was 2 years ago that they found Gannon's body. So it's kind of weird. But I will be watching that, you guys, to see if it has anything to do with Letitia. I find that really odd. Now we got some Canadians in here. I'm in Ontario, up near Ottawa. Okay, they're live, you guys. So I'm going to be bringing this to you now. Here we go.
All right, good morning, everyone. This is KCR 22-21-1623, State versus Chad. Guy Daybell. Mr. Daybell is present, represented by his attorney, John Pryor. The state is also present, too, with prosecutors. Ms. Lindsay Blake will be arguing, I understand, on behalf of the state at the hearing today. This matter is being recorded on the court's FTR system, as well as this Zoom hearing. We're conducting it remotely. It's also being live streamed on the court's YouTube channel for public access to this hearing. At this time, then, the court has scheduled for this morning a motion to sever. The motion to sever was filed on the 9th of September 2021. Thereafter, a brief in support of the motion to sever was filed on February 9th. The state filed a brief in objection and opposition on February 24th of this year. The court would note that on May 25th, 2021, in this case, a single indictment was filed in the case, which included charges against both Mr. Daybell and also Lori Vallow, including multiple counts that have conspiracy charges. And so the court has previously gone through and ruled that the cases are joined pursuant to Rule 8B of the Idaho Criminal Rules. And so this motion for severance was made with the defense request that the case or the defendants be severed. So at this time, Mr. Pryor, are you ready to present argument in support of your motion?
Yes, Your Honor.
Okay, you can proceed with your argument.
Thank you, Your Honor. Judge, in this particular case, the two cases, as the court pointed out, were joined by this court. Subsequent to that, there was an order that put a stay on Miss Lori Vallow's case. I am not afforded the opportunity to get any information about the status of the Lori Noreen Vallow Daybell matter, and I don't have information as to what her status is. However, I do know that the stay is still in place, and I've not yet seen a transport order that would transport Ms. Vallow Daybell back to Madison or Fremont County. I can only presume at this point, Judge, that there is still a stay and that there hasn't been there hasn't been any determination by this court as to what's going to happen in her case. The reason that's concerning, Judge, is that we do have a trial that is set for January. I think it's January 9th of next year, and it's fast approaching. There's a significant amount of preparation that needs to be done, and that preparation is going to include whether or not the cases are severed or whether they're joined together. And I'm not going to get into tactics, but I can assure the court that there is going to be a significant difference between how I prepare in the event the cases are joined as opposed to whether they're separate. In addition, Judge, I noticed that Ms. Blake in her response said that the only issue is Ms. Lori Noreen Vallow's mental state. If you look at my pleadings and you look at my motion, Judge, I also made note of the fact that there are some additional charges that arise out of Arizona. Those are charges that Mr. Daybell, at least if I believe what the press is saying and the prosecutor, Mr. Daybell has is not being considered for prosecution in either of those cases, although Ms. Lori Noreen Vallow is. My concern is that there's a lot of evidence, Judge, and with this court putting the limitation on my ability to discuss specific facts as to what facts I want to rely on to say this is why it needs to be severed, I put in a blank way, Judge. I said, Judge, I'd like the prosecutor, and under the rule, be required to provide their exhibits that they intend to use and allow the court, if the court needs that, to make an evaluation as to whether there is a significant conflict and whether or not it would have some sort of prejudice in either side, be either Mr. Vallow or Mr. Daybell presenting their case.
Right.
So it's not
on that point, the rule doesn't indicate anything about exhibits. The rule is pretty narrow in scope of what may be provided in support of a relief for prejudicial joinder under Rule 14, and that's whether or not there are any statements or confessions. It's narrowed in scope to that, is the way I read it, and I think the way the case law interprets it.
And it is, Judge, and the rule says the court may. It doesn't require the court to turn over the statements, but I guess the word exhibits, I guess I intended to mean in terms of statements or confessions or items of that type of matter. So my motion.
I guess on that point there, then the state has indicated that you've been provided most of or all of the discovery at this point, and I guess getting right to that issue then, if there are any particular statements or confessions that are involved in this case, I would think those would be something the court would consider, but I've not received any notice of any of that. Okay,
and Judge, I guess I would refer the court to the rule, and the rule doesn't say provided to defense counsel. That's correct. I've been provided the majority of the discovery. There are some issues as it relates to that, but the rule says that the court may request that those statements be provided to the court. It does not say it's provided to defense counsel. It says provided to the court for the court to make a determination. So the rule does allow the court to require the prosecutor to turn over those statements. But Judge, the issue still primarily is the issue of the mental capacity of Ms. Vallow. So given that, Judge, I'll defer to Ms. Blake and allow her to make her argument.
All right, thank you, Mr. Pryor. Ms. Blake, argument from the state, please.
Thank you, Your Honor. And I think to start off with, what the state would indicate is we do recognize that we are arguing the motion to sever today that was filed by Mr. Daybell. However, the state is requesting that the court reserve ruling on this matter until more information is available to the court and the parties regarding the stay in the co-defendant's case, which these are one case for trial. So when I say the co-defendant's case, I'm simply referring to Miss Lori Vallow Daybell's case, which is Fremont County case number CR 22-21-1624, and it is the companion case for trial. It is the state's position that it would be most appropriate in the interest of judicial economy and to preserve all rights of the parties that Ms. Vallow Daybell also be allowed to be heard regarding a motion to sever, since this also affects her trial rights. That being said, we are not asking for an indefinite delay on any ruling from the hearing today, but we feel that any information that may be available to the court and the parties, hopefully fairly quickly, would be useful in making a decision regarding the severance, and also wouldn't infringe upon the rights of either of the defendants in this matter. So I would.
Let me address that point then. So regardless of her status of competency or not, I assume that hasn't changed the evidence you've got in the case. And I guess the issue here is whether or not there are statements or confessions which you think the court should review in order to make a determination under the rule. And I do agree with Mr. Pryor. The rule pretty clearly states that if that's going to be ordered, that it's ordered that the attorney for the state deliver to the court that information. And of course, that's not something that would need to necessarily be disclosed here in public, and we could have a sidebar, but I do want to know whether or not there are statements or confessions that need to be considered in making the determination, and not learn that at the time those are coming up at trial. So in your evidence, do you believe there are any of these statements or confessions which go to the Bruton issue and many other issues which require me to weigh that out to make a decision?
Your Honor, the state does not believe that there are any statements. We do not have any statements that we intend to use at this time that would fall under the Bruton rule as the state understands it and has reviewed the case law. As the state indicated in our brief, we have provided voluminous discovery to Mr. Pryor. We provided everything within the state's possession at this time. Of course, discovery can be an ongoing process, and this could change at some point, but at the current time, there are no Bruton issues. There are no statements that the state intends to introduce which would trigger a Bruton issue. And so what the state had pointed out in our brief is, while we recognize that Rule 14 can place that burden on the state, I don't think there's been any indication by the defense or a real issue raised with regard to them believing, the defense believing, that there are Bruton issues in this case or any statements, and they have access to the statements that we have access to. So from the state's perspective, no, there are none, and the defense already has the statements that the court has in our possession. When we look at the cases that delve into that Bruton issue, can indicate at this time we do not have any custodial statements. So at no time after the parties were Mirandized do we have any incriminating statements one way or the other, which we would intend to use. At this point in time, well, we wouldn't intend to use them because they simply don't exist at this juncture. And again, of course, that could change. It's always an evolving issue, which is part of the reason the state thinks it may be beneficial to preserve the ruling on severance, since a motion to sever can be raised anytime before trial. And and as this case evolves, we recognize that it could go one way or the other. In addition to, if the court is inclined to make a ruling at a sooner period of time than the co-defendant, Ms. Vallow Daybell's case, can move forward, we think it would be appropriate for any ruling to be made without prejudice to allow the parties to re-raise the issue. Ms. Vallow Daybell may or may not want to raise the issue, and depending on where her case heads, the state may or may not feel that it is necessary to re-raise the issue, or depending on the outcome, if there is more information gained down the road, Mr. Daybell may want to re-raise the issue, depending on the ruling of this court. So we would be requesting that just at the outset. And I don't know if the court wants to hear the argument regarding the severance itself, or if we were just addressing whether or not the statements needed to be turned over.
Yeah, I interjected with that issue, but I would like to hear the remainder of your argument on the severance motion.
Thank you, Your Honor. And the state did file quite a lengthy brief in this case, and so I don't want to belabor those points too much. But the state's position in this case is, the first thing that we start with is under the Rule 8, and this court has already indicated these were joined under Rule 8B. It's the state's position that these were properly joined. I think this court in its August 6th order and at subsequent hearings has made indication that the joinder in this case under Rule 8B, when we're dealing with the co-defendants, was permissible. If it's been determined that under Rule 8B, a joint trial is permissible, a defendant can always raise a severance under Rule 14, arguing that the joint trial would be prejudicial. And that appears to be what the defendant is arguing today. However, case law makes very clear, and looking specifically at State v. Gamble, 146 Idaho 331, it states the defendant has the burden of showing such prejudice. When we delve further into the case law, and the federal courts seem to deal with this issue more so than the state court, at least the Idaho State Court, the Supreme Court has also addressed it. And in United States v. Fair, in United States v. Contreras, that is not the right citation. I apologize, Judge. As the federal cases go through this, though, I would indicate that Federal Rule 14 is worded very similar to the Idaho rule, providing that the court may order separate trials of counts or sever the defendant's trials or provide other relief that justice requires if there is prejudice. In Richardson v. Marsh, 481 U.S. 200, the United States Supreme Court has found that joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. That joint trials also enable a more accurate assessment of relative culpability, advantages which sometimes operate to the defendant's benefit. And in addition, joint trials avoid prosecutors bringing separate proceedings, presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. The defendant, the Ninth Circuit Court of Appeals has stated the defendant bears the heavy burden of demonstrating that the joint trial was so manifestly prejudicial as to require the trial judge to exercise his discretion on the motion to sever in just one way, by ordering a separate trial. And as we continue to go through the case law continues in both the Ninth Circuit, the federal courts in general, the United States Supreme Court, and the Idaho courts continually indicate that the burden is on the defendant, that it is a significant burden, and especially when we're dealing with cases of conspiracy. In cases of conspiracy, joinder is favored. The reason being, again, for judicial economy, we are dealing with a lot of the same witnesses, the same evidence, and there is overlap. The courts have even found that joinder is favored so strongly that even if at the end of the day, the charge itself that would require the joinder, so such as a conspiracy charge, even if a defendant is not found guilty of that, it does not make the joinder improper or a court's decision not to sever suspect in that particular situation. I think Mr. Pryor had indicated that the state raised that the only issue dealt with Ms. Vallow Daybell's mental health. That issue wasn't actually raised by the state. Where the burden is on the defendant, the state has simply responded to the brief and to what appeared to be the arguments that would be made by the defense today. In the brief, there were no specific issues outlined in defendant's brief. It appeared that there were some things alluded to. One of those appeared to be the stay in Ms. Vallow Daybell's case. It is the state's position that it is inappropriate to consider the stay in her case as a reason to sever at this juncture. Again, these cases have been on separate tracks, so Mr. Daybell has had the opportunity to be heard and to file motions, while Ms. Vallow Daybell at times has not had that opportunity yet to be heard on some of those motions, which is part of the state's rationale for asking that any decision in this case be reserved. But regardless, we believe that until a decision on the stay in her case is made, it would be premature to factor that into a decision to sever the cases. And when we look at some of the cases in the federal system, they deal with this issue and they talk about, I was trying to get to the exact case, but it's in our brief, and they do talk about the stay in a case being attributed to all the co-defendants potentially and accounting against their speedy trial clock in the federal system, which is calculated different. But the courts go on to talk about under the United States Constitution that can be a factor, but that it is not necessarily a violation of a defendant's right to continue their trial in order to have a joint trial with a co-defendant. And it would be the state's position in this case, and I think we've raised this before, but with regard to any speedy trial issue and the right to speedy trial of a defendant, Mr. Daybell, excuse me, expressly waived his right to a speedy trial. He filed a signed waiver, written waiver of speedy trial. And in Idaho, the courts have found that once a waiver of speedy trial occurs, that issue cannot be raised down the road as an issue for a delay in a trial or a reason why the trial hasn't been held faster. And I did find the case that I was referencing. So United States v. Vasquez, which is 918 F2D 329. It's a Second Circuit case, but they refer to the Speedy Trial Act in the federal system that imposes a unitary time clock on all co-defendants joined for trial. United States v. Pena, 793 F2D 486, another Second Circuit case, finds as a result, delay attributable to any one defendant is charged against the single clock, thus making the delay applicable to all defendants. So they found that basically if a defendant brings a motion to sever, which is denied, a reasonable delay analysis is applied in determining the reasonableness of any delay. Even under this standard, several federal courts have found delay alone isn't enough to establish prejudice. And again, what they continue to come back to is that joinder of trials is favored. They have found judicial economy is paramount and that the state should not be required to bring forth the same evidence in multiple trials when it could be done in just one trial. And in United States v. Casas, it's a Fifth Circuit case, 425 F3D 23. They found because the general rule is that those indicted together or tried together to prevent inconsistent verdicts and to conserve judicial and prosecutorial resources, severance is particularly difficult to obtain, whereas here multiple defendants share a single indictment. They went on to find that one of the defendants that had attempted to have his trial severed, that even though his trial may have been speedier had it been severed, the delays did not cause significant prejudice, nor did they result in the denial of a fair trial or a miscarriage of justice. They went on to just state the appellant must show prejudice greater than that which necessarily inheres whenever multiple defendants are tried jointly. And in this case, I think there's just some potentials thrown out by the defendant. I don't think there's been a definitive showing that there is any prejudice. I think one of the arguments here is the delay, but I think case law favors that delay alone is not enough to sever a trial. And the state in no means believes that the trial should be held in perpetuity, but we have a trial date right now. There's been no indication that Ms. Vallow Daybell is going to ask to continue that if it turns out that she is able to proceed forward. In addition to that, the defense has proffered to the court or indicated that there is a chance that some evidence may be attempted to be used against Ms. Vallow Daybell that deals with some issues in Arizona, and saying that if that were used, it would be prejudicial against Mr. Daybell. I think that's premature at this point. It's just an assumption or a speculation that that could happen. There are other appropriate ways to deal with that to determine if there is going to be evidence, such as a 404B motion to determine if it is applicable, if it is coming in, and if so, who that evidence would come in against. There are other things that courts have done to make sure that they're protecting one defendant's rights when there are joint trials. There have been cases in Idaho where a dual jury trial system has been used. There is case law saying that a dual trial system is not necessarily favored, but that it is not necessarily wrong to do that either. There are also times where maybe there are limiting, especially what we see as the most common remedy and what the courts have favored is limiting jury instructions. And they have found that the benefit should be given to jurors, that they will follow those instructions. We shouldn't simply say that a limiting instruction, there's no way that it would be good enough. And so I think right now with the minimal issues that have been raised at this point regarding any potential evidence, they're hypothetical at this point. We don't know. And if there were to be any evidence that would come in only against one defendant, the courts have consistently held, and it's outlined in our brief very specifically, that a limiting jury instruction is favored and is often plenty to cure any of that. And it has been used repeatedly by courts to deal with that issue when evidence would only be applicable to one defendant and not the other. Obviously, the other concern, as we talk about judicial economy, I think one of the things that we would point out as well is in a case of this magnitude, requiring the state to present two different trials obviously would have a significant impact with regard to costs for the counties involved, as well as time for all the witnesses. This is a trial that has been set for 5 weeks. The anticipation being that 2 of those weeks will be for jury selection and another 3 for the actual duration of the trial. If the state were required to replicate that same trial, obviously we are looking at the potential for another 5 weeks.
It's actually already set for 10 weeks, I believe.
Oh, 10 weeks. I apologize, Judge.
All right.
I was definitely shortening that down.
Yeah.
So I appreciate that correction. And I think, so with that, we would be looking at the potential for 20 weeks that the state would have to replicate the same evidence, essentially, require us to call all the same witnesses, require us to use all the same staff and resources to do those trials. So I think that judicial economy definitely plays into this case. I think as outlined in the rules, the burden is is clearly attributed to the defendant, and it is a heightened burden to show that the only remedy would be to sever the trials. And it is a pretty, it is a unique remedy, considering what the courts have put out. In addition, one of the most common things that the courts look at, as the court already raised the Bruton issue, and I think we've addressed that. We addressed it both in our brief and here today in indicating there simply is not a Bruton issue at this juncture. The defense has not raised a Bruton issue. They have the statements. Obviously, as I indicated, discovery is ongoing. If at any point statements are obtained, the state recognizes our requirements to immediately get those turned over to defense. And again, we recognize that that could raise a different issue, and we would need to deal with that at that time. The other thing that the state would indicate is a reason for severance, or has been found as a reason for severance, is if the defenses are completely antagonistic. In this case, there's not even been an argument or an issue raised with regard to the defenses being mutually antagonistic. And we outlined in our motion as well, but the courts have held that for them to be antagonistic is more than just defendants having a different take on the case, but that most courts have held that the defenses have to be so antagonistic that in order to find one party guilty, or one party guilty, the other party would have to be innocent, or vice versa. That it is such that if one defendant essentially puts on such a great defense, or that the evidence is not there to convict them, that it automatically convicts the other defendant. So those have happened in cases in which both defendants essentially claim it was the other one, and there's nobody else that it could possibly be. However, courts have looked at cases in which defendants have pointed the finger at one another as being the culpable party, but there was a third party involved. And the courts have found that by having that third party involved, simply pointing the finger at each other and blaming each other does not make the defense mutually antagonistic, because a jury could rationally and reasonably find that neither party was guilty. They don't simply have to find if one's innocent, the other is guilty by believing the evidence presented to them. They could believe that it was a third party or the other individual. So even if an antagonistic defense were raised in this case, unless it's to the extreme, it does not necessarily require severance. So I think given that, it appears that, again, the main arguments raised by the defense is that there's the potential for some evidence to be admitted against Ms. Vallow Daybell, which would not be appropriately admitted against Mr. Daybell. I think the case law clearly supports that if that is the case, the state can simply provide an appropriate jury instruction, limiting jury instruction with regard to that. And then it appears that the main crux outside of that would be whether or not there is prejudice based on a delay of the trial. And again, the state's position is when you're dealing with co-defendants, the federal courts, and again, we recognize they have a different clock, but they have established that the clock counts against both defendants, that there may be delays by some defendants, but that those delays alone are not enough without a showing of how it actually is going to prejudice the defendant. I don't think the defense has even put on any kind of argument or evidence today that even if the trial were to be delayed, which that's not where we're at this point in time, but even if the trial were to be continued, I don't think there's been any showing of how that would delay the defendant. There's been no argument that it would change the evidence or that it would require that, or that they would lose evidence, or that there would be anything else which would require such extreme prejudice to force a severance. And again, part of what the state's looking at there is there has been a written waiver of speedy trial filed in this case. And with that waiver of speedy trial, Mr. Daybell has waived the right to essentially use that as his argument. And that is in State v. Youngblood 117, Idaho 160. And it was the Idaho Court of Appeals. They state, an unequivocal written waiver of speedy trial signed by a defendant is dispositive of a later motion to dismiss on this basis. So I think if that's going to be part of the argument is the delay, the fact that we have that written waiver of a speedy trial actually indicates that that would be an improper reason to bring a motion to dismiss down the road. And the state feels it would be an improper argument as well for why a severance would be necessary or why it would be prejudicial. And I guess the last thing with regard to the speedy trial is I would indicate that there has been a test set out. It's a 4-factor balancing test. It was set out in Barker v. Wingo 407 U.S. 514 to determine whether speedy trial rights have been violated specifically. And it indicates the court must balance 1, the length of the delay, 2, the reason for the delay, 3, whether the defendant asserted the right, and 4, the defendant suffered prejudice as a result of the delay. So at this juncture, there is no length of delay. There has been no request by Ms. Vallow Daybell to continue the trial. We are unsure of the status of her case, but there has been no delay based on that. Because there's been no delay, we don't have a reason for a delay. The defendant, whether or not he's asserted the right, he's actually waived the right. So number 3, we know the answer to that one, and whether he suffered prejudice as the result of a delay. Because there has been no delay at this juncture, he has not suffered any prejudice. So again, any argument with regard to a delay in the case is premature at this point, simply based on the fact that Ms. Vallow Daybell's case, or her case number is stayed, her trial remains set for January, the same time as Mr. Daybell's case. So given all of those reasons, the state believes that the defense has failed to meet any burden the heavy burden that they have under Rule 14, especially that heightened burden when we're dealing with conspiracy cases, since conspiracy cases more so are favored to be joined for trial. And given the considerations in looking at the interest of all parties involved, which the courts have looked at previously, in the interest of keeping trials together, we believe at this juncture it is more appropriate that the trials remain together. Again, the state recognizes severance is an issue that may be raised at any juncture. We are asking that if there is a decision issued, first, we are asking that the court reserve ruling on it to allow Ms. Vallow Daybell to weigh in, because whether or not the case is severed affects her trial rights as well. If the court is inclined to issue a ruling before then, we are asking that it be done without prejudice, and that's to preserve all the parties' rights in the case. Again, as the court brought up the Bruton issues, at this juncture, there are none. We recognize that's evolving. So it's also we would feel that it would be fair to have that be without prejudice with regard to Mr. Daybell as well. If new evidence or information is raised, we understand that all parties may need to be heard on different issues again. But again, we believe it would be premature to make any ruling based on hypothetical evidence that may or may not be asked to be entered without any kind of decision as to who that evidence would be applicable to. In addition to the fact, we believe it's premature to make any ruling with regard to a delay or prejudice with regard to a delay, since there has been none at this point in time. So I believe that concludes the state's arguments, unless the court has any questions.
All right, thank you, Ms. Blake. I don't have any follow-up questions for you at this time. Mr. Pryor, would you like to make any rebuttal argument?
Judge, just very briefly, I've also taken the opportunity to look at the case law, and I want to make a differentiation between a couple of things that Ms. Blake had mentioned. There is a big difference, Judge, between a delay, which is referenced in every case Ms. Blake talks about, and uncertainty. And there is a difference between delay and uncertainty. And in the case of Ms. Vallow Daybell, there is uncertainty. We don't know what's going to happen in the future. Now, I would remind the court that my recollection, and the court, please correct me, but my recollection is the motion to sever was filed, I believe, in September. I believe that's when I filed this. So for the month of September, October, November, December, January, February, and now we're into March, that uncertainty has stayed there. Now, Mr. Daybell has been in custody, and I understand Ms. Blake is saying that a waiver of speedy trial is not prejudicial, but that only applies towards a delay. That case law does not apply to uncertainty. And uncertainty means that we don't know where we're going to be in a month, 2 months from now, and potentially 6 or 8 months from now. And the time to find out whether or not we're going to trial in January of 2023 is not the beginning of January of 2023. And Mr. Archibald is not able to file anything. Ms. Blake has said, well, Ms. Vallow Daybell's attorney can file things. No, he can't. He's not allowed to file anything during the stay. He can't file a motion to sever. He can't file a motion to change venue. He can't file a motion to continue the trial. He can't do any of those things. He has to sit there and wait like everybody else and find out what's going to happen in her case. And that's the uncertainty. And that's where the difference is, Judge, is the amount of uncertainty. Now, with all respect to Ms. Blake, I don't have to accept her position that there's no Bruton issues. I'm aware, when looking at the evidence, that there are a number of instances where Ms. Vallow Daybell makes statements to the police and other folks, and there are a number of instances where Mr. Daybell was interviewed by the police. And I'm not allowed, given the court's current order, to go into detail. So it seems a little disingenuous that they're going to say, well, you haven't provided any facts. Well, I'm not allowed to provide any facts because I'm not allowed to talk about the discovery, which is why I asked specifically that if the court feels that the uncertainty is not enough to sever these cases, then maybe the court should ask for the prosecutor to turn over all of the statements that they intend to use for trial, and the court can make its own independent assessment.
Okay, Mr. Pryor, I want to make a correction there. You're not prohibited from talking about the evidence to me. It's prohibition to third parties.
And Judge, this thing is being broadcasted on YouTube. And if I make a statement on YouTube about the evidence, I believe I'm in contradiction of this court's order.
Well, and you would be, and that's why I raised the issue earlier, that if there are specific issues we need to discuss outside of the public purview, then we can simply conduct what's called a breakout room on Zoom or a sidebar that's out of the presence of the general public.
And my preference, Judge, and I put that in the motion, is that the court would require the state to turn over all the statements, and I would defer to the court's wisdom as to whether or not they feel there's any Bruton issues, which is how I thought Mr. Daybell and I discussed how we would like to handle that. But it still goes back to the original argument, Judge. The uncertainty of what's going to happen in Lori Vallow Daybell's case is a big difference than the delay of any trial. So at this point, I would ask the court to issue a severance order, sever these cases. And I don't want any delay, Judge. We need to have some sort of certainty, just like some of the other motions coming up. We need to know how we're going to be handling this case, and we need to know relatively quickly. We are 9 months out, and there needs to be some certainty as to which direction we're going to go, whatever that decision is by this court.
All right, thank you, Mr. Pryor. Ms. Blake, if you have any brief counter rebuttal, you can offer that at this time.
Thank you, Your Honor. I think the state would just, again, and I think the court's already inquired of the state, we do not have any statements in our possession. When you look at the Bruton case law, we don't have the type of statements that are addressed by Bruton. As Mr. Pryor indicated, he is in possession of multiple statements. I think Rule 14 from the state's perspective does not call for or require the additional burden on the state for us to compile any and every statement that a defendant may have made to anybody, to any third party or any witness that the state would intend to use at trial. I think when we provide discovery, there's the assumption that the state may intend to use any of that discovery or evidence at trial. Mr. Pryor's already indicated he is in possession of those statements. So I think the defense already has any statements that they may be concerned about, which I think we could go out of the public purview to talk about any specific statements if he wants to address those with the state. We are not aware of any that we believe would arise to a Bruton issue. If Mr. Pryor feels different, it sounds like he's in possession of those statements already. And I think we could discuss them off the record so that the state could be aware of them. I don't think Rule 14, though, calls for or requires that the state have any additional burden added, that we essentially prepare every statement that we may want to use at trial at this juncture and provide them to the court. If the court were to require that of the state, I would indicate, given the voluminous amount of discovery and the multiple statements that may have been made to third parties or any individual in this case, would take the state a significant amount of time to delve through again to make sure that we did not miss any statements. But again, none of those statements involve Bruton issues. So I think it would be an extra burden on the state to require that. But if so, then we would need to request that we set these proceedings out a significant period of time to allow the state to make sure that we review all discovery thoroughly, to make sure that we don't miss any potential statements that we'd have to guess that the defense may think are somehow incriminating or would trigger the Bruton issue. So if the defense is in possession of those, I think we could go out of the public purview and talk about those, or they could be provided by the defense to the court or the state, so that the state is aware that they consider those concerning, and or the court. I don't think Rule 14 prohibits the defense from providing statements that they have concerns about, but the state simply has none at this juncture. And then I would just indicate, just to clarify, the state has not indicated, or if there was an appearance that we indicated that Ms. Vallow, Daybell's attorney, could file anything at this juncture, we did not intend to indicate that. The state is well aware that Mr. Archibald cannot file things at this juncture because of the pending stay, which is why we're asking for the reserved ruling on this matter, or that it be made without prejudice to allow Ms. Vallow Daybell to be heard at such time as she can, recognizing that at this juncture, she's not able to be heard regarding this issue. So I did just want to clarify that with regard to those issues that were raised.
And Judge, I would like an opportunity to respond, seeing that it is my motion.
Let's go ahead. Yes.
And very briefly, Judge, I would, I believe that Ms. Blake is misinterpreting Rule 14. The rule simply says the court may require the prosecuting attorney to provide all statements that they intend to use at trial. Putting the burden on me to provide those to the judge isn't what the rule says. So at this point, if the court is even thinking that for some reason they shouldn't sever this thing, the burden is on the state. It's not on me, and Ms. Blake putting it on me is inappropriate. It's on them. And they don't get to pick and say, well, we don't think there's any issues there. But the court has discretion. The court can say, I want the statements or I don't want the statements. That's clearly within the purview of the court. But it's not within Ms. Blake to say, well, we don't have any Bruton issues, so we don't need to provide them. That's a total misinterpretation of the rule. The rule requires the state to provide them if this court deems them an issue important enough for them to review. I don't want any delay, Judge. I need a decision one way or the other as to whether this is going to be severed, because I have a significant amount of preparation that I'm going to need to do, and there's going to be an impact which way this goes. And this has been pending for, this motion's been pending for 5 months, and it hasn't changed in 5 months, Ms. Vallow Daybell's position in terms of where she's at. We have no certainty as to where it's going to be in another 5 or 6 months. And I think it's inappropriate to put Mr. Daybell hanging in this situation with the idea that we don't have any certainty as where this is going. Given that, Judge, there's a difference between delay and uncertainty. And given the uncertainty, Your Honor, I would respectfully ask this court to sever the cases.
All right, I appreciate the arguments from everyone. I am going to take the matter under advisement at this time. I'll consider it submitted, and the court will issue a written ruling on the motion.
Thank you, Your Honor.
All right, anything else we need to bring up on the case this morning, Mr. Pryor?
I don't believe so, Your Honor. Thank you for your patience in this matter.
Thank you, Mr. Pryor. Ms. Blake, anything further from the state?
Your Honor, the state was going to ask, and I think I'd leave it to the court, but I think we may be able to go off the record for this. But the state did just have a housekeeping issue with a hearing that we had set yesterday. We just wanted to clarify something with the court with regard to that setting.
Okay, why don't we go ahead and conclude this hearing? We will go off of the broadcast of the hearing on the YouTube channel. We'll have the court reporter included, however, and let's take up a breakout session where we'll make a transcript of that, and I'll just discuss that housekeeping matter with counsel. So the motion to sever is concluded. If you want to go ahead and stop the live stream.
Okay, so there we have it, you guys. Missy T, Chad waived his right to a speedy trial. That was done a while back, so that's not an issue right now, and he cannot bring that up and use that now at this time. So let me just get organized here, you guys. Move my keyboard so I wouldn't hit it again to pause everything. So I'm going to let you guys ask any questions that you want to ask regarding this. And I will answer what I can. And then we are going to end the live. I'm going to be going shopping with mama. So does anybody have any questions? Maybe something they didn't understand in it that maybe I can answer for you guys. So basically what they're saying, and I know, like I said yesterday, you guys, I do understand what Pryor is saying. He has to prepare for a death penalty case. He wants all the information that is going to be used at trial. With that being said, he can't start a proper defense when he doesn't have all the information. We don't even know. Prejudice means that they could bring it back at any time. So he needs all the information and all the disclosure that's going to be used at trial. Right now, because Lori's case has stayed, anything that any statements or anything that she has given while in the state hospital has not been put into record yet because they just don't have it yet. And he can't go forward, to prepare for trial, not knowing what is actually going to be there and what's not. And a lot of this was in regards to Lori. Yeah, I think it was extended for another 3 months. The real agent says costs more money to separate the two trials. Well, yeah, it will be a lot more money because you're going to have two trials instead of just one. But if there's two very separate issues, like Lori's also been charged with killing her ex-husband. Chad has been charged with the Tammy death. So, I mean, there's some things there that are going to overlap and evidence that may be brought in that don't apply to the case that they're trying. So, which may confuse the jury, is what Pryor is saying. And I get it. I get it. As much as we don't like him, I do believe that this should be severed. Will they get it? I don't think so. Not at this point in time. But I do believe that they should be severed because she has another murder charge that she's facing all on her own. And if information from that trial or from that incident gets brought over into an incident that Chad is not part of, then it's bias against Chad, right? Because the trial is going to be together, so the decision is going to be a joint decision. Thank you, Comp2. I appreciate you so much. So I do get where Pryor, even though we don't like him and everything else, and we just want this to go forward, I do get where he's coming from. If I've got a client and he has a co-defendant, and yet the co-defendant is also charged with other things, that's going to be brought into my trial against my client that has nothing to do with him. You know what I mean? So I do get where he is coming from. Okay, so no, it's not severed yet. Okay, so the next one, thank you, Comptute, again for your super sticker. I appreciate it so much. Okay, so Strawberry Wine says, couldn't they just move the trial a bit further out because of the current stay for Lori? No, they've already done that. They've moved the trial out and out and out because she was in the state hospital. The trial has been set to start in January of 2023. That's not fair to Chad to keep moving it further and further because she's not competent. We want to get a conviction, right? So let's get this thing going. Thank you, Des. Yes, Fluffy Hedgehog says, but it's linked to the disposal of the children's bodies. Yes. All those cases that they're charged together regarding the kids, yes, that should be tried together. But because they each have separate individual charges also that will be brought into the trial, that evidence is going to go against one but not the other. But being it's joint, it's going to be, I think it'll be too confusing for the jury. And I think that's what's going to end up happening is this is going to be severed. But at this point right now, because they don't know if Lori is ever going to even face trial, that's going to depend whether they can bring her back to competency or not. I think this will be decided further on down the line, maybe in July or August. I don't think that it should be severed until then, in case she is been brought back to competency. But then on that case, they still have argument to sever because there's going to be other evidence that's brought in that's not against your client, right? It's only against the other. So I do believe for the best interest, it should be severed. But that's just my opinion. And I think that may end up happening anyway. Yeah, if she's not brought back to justice, she will be locked up there until she is competent and may not ever stand trial. It's going to be interesting. Oh, I believe she is too, but she's playing the part very well. It could come to more than 3. Because Chad also has a charge for Tammy. Now, I don't remember if Lori was in on that charge too. I'd have to go back and check the record, but I know he's charged with killing his wife. She's charged with killing her ex-husband. They're charged together with the deaths of the kids. It doesn't mean because I say so it's true. I'm just giving my opinion on certain things. Well, I'm glad to have you here, January. So is there any other questions that you guys have that I could possibly answer? Okay, so Lori is charged too? Okay. So they would be facing the charge with Tammy, the charge with JJ, the charge with Tylee. Lori has, and then Chad is also charged separately with insurance fraud. Lori is also charged separately with fraud and with the death of her ex-husband, Charles. So I believe, and this is only my opinion, you guys, and I'm not saying that just because I'm saying this, it makes it true. I'm saying this is my opinion from 30 years in working in the legal field. I feel that there's too much exterior on each side, that as much as the charges are the same, there's different also, that it should be separated. Because there's going to be, I think what this is setting up is a lot of more emotions for things to be kept out of the trial, because it only applies to one and not both. When you get into a situation like that, you've got, you're giving reasonable grounds for appeals. And we don't want that. I do believe, personally, my opinion only, that these trials should be separated. Yeah, we just want justice. But I do believe that they should be separated. I don't think the judge is going to do it at this point, but I do feel down the line, I'm going to give a guesstimate. I think maybe June or July that there will finally be a decision to sever in this case. Like I said from the beginning, as much as I don't like John Pryor, I'm kind of leaning on his side that if she's not brought back to competency very soon, within the next month or so, that yes, they should be severed. But on a whole, I believe they should be severed anyway, because of the charges individually on each of them that are not part of a joint, if that makes any sense. Thank you so much, Lee. Lee says, how is competency being restored? Medication. I don't think we have this concept of restoration in Germany. Well, thank you for that, Lee. They do have her on medication, and she also has several psychiatrists and everything that, trying to undo the work that was done via Chad and their beliefs of this end of the world. And there's 144 that are only going to be saved, the end of time, stuff like this. The brainwashing, and I think she's brainwashed herself, and she knows how to play those games. So all they have to do is prove that she understands her charges and that she could assist in her defense. But she's playing this game that she doesn't get it. Why am I charged? Like, I'm following the Lord. So yeah, it's pretty wild. It doesn't, 99% of the time, Lee, this does not work. It's a delay. I'm actually very surprised that it's been delayed this long still. So thank you for that question, Lee. Yeah, Terry, I get it too. Like, could you imagine being a key witness? The only other thing that I could see is that no information can be brought forth, which I don't think the prosecution wants. When the prosecution goes in front of the judge and jury, they want to use every piece of evidence that they can against the person on trial. So if they only do the Tammy and the children case together, they can't bring any evidence in regarding the other charges, which are separate. So what I think they should do is So they can throw everything they have at Chad to have Chad's trial separate from Lori's. So then when Lori's trial does come around, they can also use the murder charge that she's facing with her ex-husband, and everything can be grouped together. So they can use every single thing that they have against Lori against her in one trial. So that would be Tammy, the kids, and Charles. Because I don't think it's fair that they use evidence regarding Charles in the same trial against Chad, because it's irrelevant to Chad if he's not being charged with that murder. So there's going to be stuff that's brought in, and it's going to be decided on a whole instead of individually. It's just very confusing for a jury. And I'm looking at the straightest line to a conviction. And I believe at this time that straightest line to a conviction is to do them separate. So you can throw everything you have against them individually, and the jury is focused on that person and that person alone. When you're trying to tell a jury, okay, well, look at this evidence is only against Lori. So you'll have to, make a decision using this evidence that we're going to bring out only against Lori, not against Chad. It's going to confuse the jury too much, I think. That's just my personal opinion. Thank you, Lee, for subscribing. I appreciate you. Yes, please hit that like. But they could use information from it to show her mindset and what she was capable of. Somehow they can get that into this trial. I do believe that is going to be held in Arizona, but it doesn't stop the prosecution from bringing information regarding that into this trial when it has nothing to do with Chad. Yeah, I just think that it would confuse the heck out of a jury, and you want your jury focused on what you are trying to get your charges, right? You're trying to get a conviction, and I think that a lot of that would just confuse it. I think in my personal opinion, I think that they should be severed. I didn't agree with the joinder to begin with, because I do know that it is going to cause a lot of confusion. And with a jury, it's like, oh, well, we don't think Chad had anything to do with this. You take a risk. There's big risks in doing this. Is it feasible financially wise? Absolutely. Is it feasible so the witnesses only have to testify once? Absolutely. But is that going to bring you what you want? Thank you, sis. I appreciate you. Thank you. Thank you so much. I appreciate that. So yeah, so I break it down the best that I can from what, like I said, I worked in the legal field for over 30 years in criminal law. I do know that some laws are different between Canada and the US. I'm in Canada, but there's a lot that's the same. Anything else on Letitia Stout? Yes, she is back in court, and I will be covering that. I believe she's back in court on the 25th of March. It could be vacated though, depending on her rehabilitation or whatever the hell she's going for again. Similar to Lori, another competency hearing that she's going under or whatever. Thank you so much. And you're very welcome. You're very welcome, Terry. Very welcome, Bebop. Okay, so I'm going to wrap this up, you guys. I want to thank everybody for being here. I want to thank you all for your super chats and super stickers. I appreciate that very much. It shows appreciation for what I am doing and bringing this to you guys. I am going to be watching the records and the dockets. So as soon as I do see the judge's decision on this, he is left it to advisement, which means he's going to make a written decision on this. So I will be watching the court filings for that, and I will bring that to you as soon as that is up on the court record. So with that being said, you guys, thank you for my mods. I appreciate you. You're the best around. Thank you to all the subscribers and the members. Thank you very much. Thank you for all who have subscribed today and became a member today. You guys are awesome. You're very welcome, Vicky. I do my best. So with that being said, you guys, I'm going to let you get back to what you got to get back to. This will be private for a bit for me to be able to enter my information and description and everything. It should be back up and available within 15 to 20 minutes. So everybody enjoy the rest of your day, and we will see you on the next one. Take care. Bye-bye for now.